Part 2 of this module is dedicated to illegal bargaining and workforce lending. Generally, outsourcing agreements and obviously most of the IT services agreements are based on the same economical model, which is time and materials agreements. This means that a company will ask for services which will be invoiced on a time and material basis. Each day performed will be invoiced as such. Indeed, a service provider makes his employees available to a client to carry out tasks, missions that the client does not usually carry out or for which he needs a specific know-how and experience not available in his company. You have to know that making employees available within the client's premises can lead to a high legal risk. Indeed, if in most of the cases, making employees available to perform services within your client's premises will be totally legal, you have to know that in certain circumstances, this will lead to either illegal workforce lending or illegal bargaining of the workforce. For instances, there are various purposes to have the employees of the service provider within your premises. First is the need for services from specialist companies. You do not have within the firm the specific know-how, and this service provider will have. Another example is the installation of a new IT system in your firm. For instance, the training of your users of a new IT system will be much more efficient if it's done by the staff of the service provider live within the premises. Of course, during go-live starting or parameterization operation, while you are implementing this new IT system, it is quite obvious that the presence of the staff of the service provider will be much more efficient and helpful for your teams when it's done within the firm. What is an illegal workforce lending? Workforce lending is not always illegal. Workforce lending is to make employees available to your client benefit. It becomes illegal when, first, it's a profit-making venture. Two, when the lending exclusive purpose is the lending itself. It's illegal when there is no other purpose for the lending of the employees. What would be another purpose? For instance, if you are providing a specific know-how to your client, then the purpose of the lending is not exclusively the lending itself. You are providing a specific know-how, a specific knowledge to your client. Then, this service agreement is not illegal. Lending of employees, when it's exclusive, is not illegal when it's performed by firms that are authorized to do so, especially and exclusively temporary work firms, what we call in France intérim. But one can only have recourse to temporary workers when specific conditions are met, namely to replace an employee, for instance during a sick leave, or another condition, another circumstance when you can have recourse to the temporary worker is that when you have an increase of activity which will be temporary. If you are not in these circumstances, you cannot have recourse to temporary workers. And then, if you ask for a service provider to lend employees, this will be illegal. Typical illegal workforce lending is false subcontracting. This occurs when an employer, a firm, does not want to take any risks by employing people. So what they will do, because nobody knows what tomorrow will be made of, they prefer to ask a company to lend employees. So the employer, by this way, is not employing people for a specific or undetermined duration. If you want to put an end to the work performed by these persons, he will just have to give prior notice. There will be no labor law applying to these people. This is why, so as to protect the employees, the persons who will perform this work, such activities, such ways of doing are illegal. You also have the well-known case of phony self-employed workers. When you want to work with someone, usually you don't have the choice to say, okay, either you will be an employee, but I would rather prefer that you will be a self-employed person. Because if I do not need you anymore, I can put an end to the agreement without paying for anything, as part of redundancy, for instance. Legal persons usually don't have that choice, except if you can prove that this person has a specific know-how, and then you will be able to have a services agreement with this person. If you cannot prove this, then this has to be an employment agreement directly between this person and your firm. Of course, since illegal workforce lending may lead to crime and liability, you have to be very careful in the content of the services agreement you will pass with the service providers. The judge may investigate to verify if in the service agreement there are not some elements that would reveal the offense of illegal workforce lending. For instance, please make sure that in the service agreement you have a clear definition of a performance of a clearly defined task. Lump sum remuneration is also a good practice. Identifying in the service agreement the specific know-how that is made available is very important. You also have to make sure and to provide that the service provider maintains authority over his employees. This is a major criteria to make sure that this is not a lending of workforce which is illegal. The clear and precise definition of the service to be carried out enables one to demonstrate that the employees of the user company are not competent to perform that service. And as a result, the service provider needs to provide some of its employees in order to carry out its contractual obligations. Specific supervision of employees is mandatory. You have to make sure that the service provider is still the person that will supervise and monitor the activity that are performed by his employees within your premises. The mission of the employee made available must be defined by the service provider and not by the user company. The employee must report to the service provider and not to the user company. Otherwise, the operation may be considered illegal. The hierarchical relationship with the employees must continue in an obvious and permanent manner. For instance, the user company cannot blame directly the employee of the service provider. It is the duty of the service employer to do so. So, no emails directly between the user company and the employee. The email must be sent to the employer of such employee. he will then play his role as an employer and blame such employee if he has to do so. The second offense that can be committed in such IT agreements after illegal workforce lending is illegal bargaining of employees. These two offenses are not quite different, as we will see. What is illegal bargaining of employees? It's an operation consisting in providing employees for a profit-making venture. It is the same for illegal workforce lending. But what is different here is that the operation will become illegal if it has the effect of either causing damage to the employee concerned or eluding the application of laws, regulations, or collective bargaining agreements. Typically, if you enter into a service agreement to elude the conditions to have recourse to temporary workers, then the offense of illegal bargaining of employment is committed. The scope of authorized operation is still very large. For instance, workforce lending or bargaining of employees for profit-making venture within the framework of temporary work as defined by law is licit. Delegation of employees when the objective is not exclusively the lending of the workforce is totally legal. Of course, because you can make employees available when they have a specific know-how that the user company does not have. Third, last but not least, if the lending is for non-profit purposes or for non-profit venture, then it is legal. But usually, if you bargain, it's rarely for non-profit purposes. What are the sentences of these two offenses? They are identical. As you will see, the criminal sentences are quite strict. Committing such offense may lead to a maximum of 2-year imprisonment and a €3,000 fine. Additional sentences might even be prohibition to exercise the activity or display and publication of the judgment that has sentenced the firm. This is not good publicity. As you may also know, criminal sentences for legal entities, as opposed to individuals, is that the fine will be multiplied by 5. You also have to know that the user company will be considered as a co-author of the offense, and that the user company thus incurs the same penalties. If you cannot prove that this specific person has a specific know-how that it will provide to you, obviously you will not be entitled to enter into a service agreement with this person. The relationship will have to be an employment one. You will have to enter into an employment agreement. Not doing so may lead to a requalification of the service agreement into an employment agreement.